want you to imagine something for a second. Here you are building this network marketing, this MLM company. Everything's going great. You've got this giant team, and all of a sudden it unravels. It just comes crashing down, all due to broken promises, miscommunication, a lack of trust. This is exactly what happened between Brian Underwood, Michael Rutherford, and Prüvit. And that's what I want to get into today in this video, because there's some lessons we can learn from the lawsuits and the settlement that just came down. Hi, my name is Troy Dooley. I'm the Beachside CEO. Let me disclose real quick that Brian Underwood has been a dear friend almost 20 years. Michael Rutherford, almost the same amount of time. Prüvit has been a long-standing client, and at least 2 out of the 3 founders of Prüvit, Terry LaCour and Brian Underwood, have been clients both collectively and individually over the last few years. So I've got a good take on this, maybe a take from the personalities that other people don't have. And that's why when I got the settlement yesterday, it's a 34-page settlement. It's very insightful. We're going to publish that. You'll be able to read the full thing. But one of the things that stood out to me was that Rutherford had really burnt through all of his money. He had no money left. He represented himself in this case, and he presented it well, at least to this judge, and the judge ruled in his favor. So let's break it down. Rutherford has been with Prüvit. He's an OG. He's one of the originals, if not the first person that Brian went to. They both classified themselves as best friends. They had been together through several ventures, ups and downs over the last few years. Excuse me. And I think that's very, very important, because as they built this, they also had a side agreement that was disclosed inside of this case that Brian got a certain percentage, and that was up 25%. Everything that came through that account, if you will, the ownership of the Prüvit account, 25% of that went back to the CEO and founder. We're gonna address that in a second, because that's something that I think can be an Achilles heel. So I want to cover that. But here's the settlement. In July 2023, a dispute led to the lawsuits in Texas and Nevada. They settled with a written agreement. Now, this is a couple of years ago. Rutherford agreed to stop all Prüvit activities. That means he would not publicly be talking, promoting, doing anything with Prüvit. No soliciting, no social media, nothing. He had to unfriend non-personally enrolled provers or reps. Standard. I mean, the appellate courts have already ruled in this. This is case law, really, that says the company owns the line of sponsorship. That's the way this works, except for personal directs that you had a relationship prior to Prüvit or prior to your company. It doesn't matter which company it is. In return, Prüvit promised to protect his downline, no relocation. Now, here's what this means. That means they weren't going to take and lower his revenues by moving people above him or outside to other people, friendly people, if you will, to eventually make his check go to zero. You may be wondering, well, Troy, is this common practice? It is in some companies, absolutely. So this was something that they wrote into the agreement for his protection. Prüvit won't be doing this. And they were capping how much he would earn to $100,000 a month. So anything above the $100,000 a month, minus 25%, so $25,000 a month to Brian Underwood, the CEO. Anything above and beyond that would go to Prüvit or go to Underwood. I don't know. That's in a separate agreement. They also had a 2-year non-solicitation clause, confidentiality, non-disparagement, and notice and cure procedure for any violations on both sides. So if they thought that Rutherford was doing something in social media he shouldn't, or he was cross-soliciting to someone, then they would send, they had a procedure in place, vice versa. If he decided they did something, then he could do this procedure to cure the situation. But everything fell apart. I'm going to get into why it fell apart here in just a second. But Rutherford claimed Prüvit breached by changing its compensation plan to reduce his earnings, allowing downline departures, withholding payments without proper notice or cure periods, and terminating his account. Prüvit countered that Rutherford violated social media and solicitation rules. The case went into breach in February of 2025, and it went before Judge Mazant in the Eastern District of Texas, which is what we're covering right now. This is it. So here's what the courts found. This is important. The preponderance of proof that they found that Prüvit did breach the settlement agreement. The key points here, and this is something I want company founders, CEOs, C-suites that are listening to this, pay attention to this. Prüvit failed to pay the commissions, including routine payments and ownership pool bonuses, and didn't maintain transparent accounting. Rutherford had to rely on a liaison without direct access. Remember, he was ostracized from the company. He was still getting paid, but he could no longer be a part of the company. They terminated his account without valid cause or following the notice and cure rules. No credible evidence supported Prüvit's claims of Rutherford's breach. Their accusations, like social media violations, were unsubstantiated or misinterpreted, or they misinterpreted the agreement. Underwood wasn't personally liable beyond the 25%. So he's got to take care of this. But listen, this is big. Misinterpreted the agreement. Prüvit's legal team wrote this agreement, from my understanding, and Rutherford agreed to it because, and this is my supposition, this is my opinion, I believe that like many legal teams, the legal team wrote this in a ambiguous language, similar to policies and procedures and terms and conditions. They made it to where they could argue what they were doing. They left it open for interpretation in the courts, and in this case, the courts ruled against them. Because sometimes when we leave agreements ambiguous, here's what happens. There isn't room for ambiguity because there are terms that are valid with definitions that are used, and you're going to see what I'm talking about here in a minute. Rutherford proved damages based on iPayout ledgers showing shortfalls. iPayout is a third-party payment provider that a lot of network marketing companies use. The court awarded, Rutherford $235,166 in monetary damages, plus attorney's fees. Now understand, he had attorneys, but he couldn't keep paying them, so now he gets paid as an attorney, I suppose. Post-judgment interest, so all of that interest has to be paid for that money that didn't come to him. They're going to have to determine at what interest rate. They will do that. And ordered Prüvit to reinstate commissions perpetuously through July of 2026. Other claims like fraud were not addressed since they were not litigated at trial. Now, here's where I want to get into the lessons learned. This is very, very important. I want to look at this. For companies, you need to draft specific agreements. Look, I know you're trying to wiggle room. I know you want to try to do what's best for your clients that are out there, all the attorneys. You cannot do that. You're going to have to use what we call a trust-inspired, purpose-driven narrative in your agreements. And either you guys going to have to figure out, yeah, we can argue and defend this, or you're not. But you cannot just keep using ambiguous language if you think it's going to go that way, because I'm seeing a shift in the courts. I'm seeing a shift in all the documents that we're reading. You've got to have clear terms on the commissions, the downlines, the payments to avoid all this. You've also got to make sure that both parties fully understand the notice to cure provisions. You can't just arbitrarily decide this. Here's the other thing that happened during this time period, and we just read about this. Prüvit changed their comp plan. In Prüvit's opinion, the settlement was, for lack of a better term, I'll use layman's here, null and void. Hey, he isn't living up to his end because we changed the comp plan and now he needs to do all these new things. That's not how that works. The settlement was written that as the comp plan stood on the day of settlement, Prüvit agreed to pay those commissions. The fact that Brian Underwood decided to change the comp plan, try to boost revenues, try to get more excitement in, I'm all for that. The dilemma is you cannot change you still got to pay him. You cannot change and expect new qualifications when you've locked a guy out of your company. It doesn't work that way. So companies, be diligent on that. Document, man, we talk about this with compliance teams when we're coaching them. Document the violations with solid evidence. No vague, hey, this is what we think. That doesn't work that way. And what we're finding is reps now pooling together with certain law firms to say, look, if this happens, will you protect this? It kind of goes back to the old association that I helped found with Rod Cook, the Distributors' Rights Associations. They're protecting themselves. They're focusing in on what's going on because they don't want to stand by anymore and say, look, this isn't right. If we're independent contractors, then we need to be independent, but yet we need to be balanced on both sides. It's going towards, I believe, more of a franchise methodology or a licensing methodology where both sides have some wins. If you're trying to create terms and conditions, policies and procedures, settlements that are one-sided to your company because you're letting your emotions get involved, I would strongly stand against that and say, look, man, let's sit down here and think this through. Let's figure out what would be best for you and the company, be best for the rep and the company, be best for your reputation. I mean, that's a big thing right there. For the distributors, listen, this is important. This just isn't, the Troy's on the company. No. Listen, you've got to be able to monitor your commissions constantly. You need to know where you're at, what's going on. Also, when you sign these agreements, you need to make sure that you're abiding by those agreements. Constantly look at that. Comply strictly with the restrictions for non-solicitation. Look, there's ways. I get reps come to me all the time because we've been representing clients all over the place with all these companies. You guys know we're into protecting the house, and I'll have a rep call and say, Troy, I met you through XYZ company. I appreciate everything you did. Can you tell me how I can move away from your client because it's time for me to move on? My dreams have gotten bigger, or whatever the case is. And we'll tell them every time, look, here's the best process. Start a new social media account and start from scratch. Go through your list, get all your friends over there, explain to them what's going on. Do they do that? Most of them won't do that. That's tough work, man, when you've built something. So you go to plan B, and plan B is to go through your list of friends. And what you end up doing is you say, look, I'm gonna block or restrict them. Another way around that is to take everything that you're posting, build a different type of list. You can do this inside Facebook. I don't know if you can do this in some of the other social media. It seems like Facebook is where they hit us on, or they hit you on Instagram. That's the other one that you got to look at. So what you do is you look at where you're posting. Who can see your post? Who can't see your post? When you see that, you know, oh man, that was a cross line to me, then for a while you've got to block or restrict, unfollow, unfriend, whatever your agreement says. Please do that because it's held to the letter of the law. In this situation here, Prüvit kept saying you need to block, you need to block, you need to block. Well, the agreement actually said you need to remove or unfriend. And those words are important. They're as important as a comma in a sentence. So please stay up on top of that right there. For compliance and legal teams, this is important. I can't emphasize this enough, that your contracts have to be created in a way for not having any miscommunication. I do a lot of agreements. We hone in on what is it that we're doing. And with all my clients, I've got clients inside and outside of direct sales, and I'm constantly looking at the definition page. That's the page I look at, and then I go back and I look at the agreement. Once I've done that, then we shoot over usually to the legal team and say, look, I need you guys to look at what I found and tell me if we can word this different so that we have what we're looking for. Sometimes in our favor, sometimes to protect us against a divorce, because the honeymoon period is great, okay? But there's really 99% of the times there is no prenup agreement in direct sales. You're just signing the terms and conditions, policies, and procedures. And then on the way out, you're thinking, man, I wish I'd had this written a little bit better. That's the key. That's what we've got to look at. Let me go into the conclusion here. Poor communication and broken trust. That's all this was. This was two friends that were going through all kinds of crap in their own life. And it was a mess. And then all of a sudden, it's like it's a mess on the inside. And all of a sudden, the trust is broken. The communication breaks down. Just like in every relationship, business, personal, if there's a break in the communication, if there's a break in trust, it's tough to get it back. So what do? You got to focus on trust-inspired, purpose-driven communication. You've got to be able to build the narrative, and then you've got to walk it out. Don't be a hypocrite. Don't get on stage talking about all the rah-rah, all the great stuff, how you got to build it from the inside. You got to be pushed. That's just stupid if you're not going to walk it in real life. So don't get up there trying to manipulate. If you want to persuade people into a better life, I'm all for that. But then don't go on the backside and try to screw them out of their money or anything else. Do it right. If you need questions on this, man, reach out and contact me. This is what we do for a living. And we've got many clients that are out there without the lawsuits, without the bad reputation with reps, without the inconsistencies, and we can do it for you. So, end of it, I want you guys to learn from it. We're going to post this. We'll post the video. We're going to load the settlement up for you guys to look at. You'll be able to go through there in detail, especially the legal teams and compliance teams, fully understand what went wrong and how to fix it. That's the key. So, with that being said, I will see you on the next video. Live well, finish strong, and if you're in network marketing, act like it.